No, she'll be great.
Exactly. That's my
As you're wandering in, make sure you pick up the two handouts at the back, if you will. I love your belt.
I know why.
Christina Jackson.
Are you first today?
Yeah. Oh, I'm so glad. That's very good. You too. So how long have you been? Oh, okay. Okay. So do camera work?
Oh, there.
So you just I'm hoping
yeah, I know. You never know. I
So nobody sits in the room. We're just in it. Why, she's texting where are we?
No.
I'm gonna take the walker. It's actually very nice.
Everybody got your hands out? Everybody gets
Well, one more will get them screen.
Hi everyone, I'm Wendy Kuchar. I'm on the board of Idaho Women Lawyers, and I'm delighted to welcome you this morning to our CLE on pregnancy discrimination. First of all, I would like to especially thank Parsons, Bailey, and Latimer for co-sponsoring this event. Not least of all because we got the amazing talents of Susie Headley helping us organize. And as many of you have mentioned, this is perhaps the best attended and best organized event all year. So thank you. I'd also like to thank Brenda Bodges for helping organize, and Amy Lombardo for being the one to pitch this idea at the outset, which clearly has struck a nerve in our community. Finally, if you haven't signed up for CLE credit, there are sign-up sheets outside. Make sure your phones are at least on vibrate. I know your offices probably want to reach you right now, so please do that. I'm delighted to introduce our speaker today, Christina Jepson. She's a shareholder at Parsons, Bailey, and Latimer, and a chair of the firm's Employment and Labor Law Practice Group. She's also an adjunct professor at the University of Utah. We're so fortunate to have her today, especially because she traveled here from Salt Lake to be with us. So thank you so much. Thank you.
Good morning. This is going to test my eyesight just a little bit, maybe yours too. Did everyone pick up the handouts in back? Okay, there's two. So grab those if you haven't. So as mentioned, I practice employment law. I've been doing it for 20 years, unbelievably. And much has changed over those 20 years. Some of you who have been practicing, and this is a really moving area of law, and I think it's really exciting. How many of you here practice employment law on some sort of regular basis? Okay. How many of you are just here because you're interested in the topic? All right. How many are just here because you want CLE and you have no interest in the topic whatsoever? How many are here because you're pregnant? Just kidding. So, oh, you are, good, okay. So I go to yoga with my husband quite a bit, and the yoga teacher will often say, is there anyone in the class who's pregnant that I should be aware of? And I want to just raise my hand just to make my husband go into cardiac arrest. So I come from the employer perspective primarily because I represent employers mostly. But I also will counsel plaintiffs from time to time. I don't bring charges or complaints for them, but I'll counsel them. But also, in terms of my perspective here, I'm a woman. I've had a couple kids, have a couple stepkids, who've been pregnant. So I'm very interested in women succeeding in the workplace, and this is a big part of it. So I think I have a pretty balanced view on this topic. But if I don't, raise your hand and tell me if I'm wrong. Pregnancy discrimination is probably a little bit broader than that. We're going to be talking about discrimination, accommodation, kind of the full range of topics that come up with employment law. And we're going to talk a lot about this Young case. Has anyone heard about it? We're going to talk about that, but I want you to keep in mind that in a lot of ways, Young is not what matters most in this area. So we're going to go through it, but so much of this is about the ADA, and I call it the ADA because I don't like to say ADA. So anyway. So when you're talking about pregnancy in the workplace, there are really three major laws that you need to keep in mind. And the first one, we're going to call it the PDA today, but it's the Pregnancy Discrimination Act. And when that was passed in the 1970s, it was passed to make it explicitly clear that Title VII's inclusion of sex discrimination also included pregnancy discrimination, pregnancy-related conditions, those sort of things. It seems pretty obvious, but some people, the obvious isn't obvious, and you have to kind of knock over the head with a statute. So it was passed. The first clause of the PDA says sex discrimination under Title VII includes pregnancy discrimination. So if you come to work pregnant, they're like, yeah, we really don't like pregnant people, you're out of here, which happened back then. Maybe still happens from time to time. That is discrimination. Now, what's really interesting for our discussion today is when they passed that statute, they included a second clause in the pregnancy discrimination. So on top of saying, if this is part of sex discrimination, there's a second clause in the PDA that says, we'll look at the exact language, but basically that you have to treat pregnant workers the same as other workers with similar ability or inability to work. And so that's caused some pause, like what does that mean on top of just calling it pregnancy discrimination? So we'll talk a little more about that. And then you have the ADA, which is really, really critical because for those of you who don't practice employment law, under the ADA, you're required as an employer to accommodate disabilities if you can do so without undue hardship. And prior to 2008, there was a lot of case law that really limited what could be called a disability. And Congress again, enacted legislation, amended the ADA, which is why it's now the ADA. But so now it's much easier to show that a medical condition is a disability. And many conditions related to pregnancy now qualify as disabilities and have to be accommodated if you can do so without undue hardship. So that's really changed the entire landscape. And then finally, of course, you have the Family Medical Leave Act, which only comes into play if you have 50 employees, and there's different ways of counting that. But if you qualify under FMLA, you have to give employees who qualify, they have to have been there a year or worked a certain number of hours. You have to give them 12 weeks of unpaid leave for either a medical condition or to take care of a new child. And that applies equally to men with respect to taking care of a new child. So those are kind of the three main areas. And as an employer or someone representing a plaintiff, you really have to think about all of those, because you might decide, okay, this person doesn't qualify for FMLA leave. They may qualify for some leave under the ADA. So it gets pretty complicated in sort of the Employment Lawyer Full Employment Act, because it is very complicated. So the PDA, as I mentioned, amended Title VII to explicitly prohibit discrimination based on pregnancy. And it's not just pregnancy, it's current pregnancy, past pregnancy, and that was kind of critical because you had the scenario where people would come back to work after having a baby and they'd be like, oh, yeah, that's not gonna work out. New mothers don't work so well here. So, a past pregnancy, a potential or intended pregnancy. So, thinking Mad Men days and, we don't want women of childbearing years because, we know you're gonna be reproducing and all. So, an intended pregnancy, and then also medical conditions related to pregnancy or childbirth. And I think that one's really interesting because it's explicitly in the PDA, and yet we have the ADA, and how do those two kind of work together? It's not entirely clear, but you cannot discriminate based on those. Now, this isn't an accommodation law, it's a not discriminate law. So, what's kind of caused the new excitement in this area is almost a year ago, the EOC issued new guidance, which you should have, regarding pregnancy discrimination, pregnancy accommodation. It's a 50-page report. There's a lot of really good information in there. They also have questions and answers in a fact sheet. You can find those all online if you're interested. And at the time, this was the EEOC's view about how it believed pregnancy should be treated in the workplace, and specifically the PDA. And at that time, no courts had commented on the EEOC guidance. So when I was talking about this a year ago, we didn't really know how this was going to all shake out, and we still don't entirely know. But the guidance in this case was really unusual because what was going on is the Fourth Circuit had decided this case called Young versus UPS. And it was about a woman who sought light duty work when she was pregnant. She worked at UPS, she lifted packages. And UPS provided accommodations for some employees, but not for pregnant employees. And the Fourth Circuit had rejected her claim, and it was pending before the US Supreme Court. And so the EEOC hurried and came out with guidance basically to influence the Supreme Court decision. And the Supreme Court took note of that and didn't really like that when they finally ruled on Young. But they wanted to get ahead of the issue. They issued it without any sort of comment period or anything like that. So so keep that in mind. The court ended up rejecting part of the analysis under the guidance, but a lot of the guidance in there about accommodation is still very useful and probably valid. I don't see any reason why it wouldn't be valid. So the case that I'm talking about, the Young versus UPS case, the Fourth Circuit had said, no, an employer does not have to accommodate pregnant employees in a situation where they were accommodating other employees. And it created a split in the circuit because some other circuits had said, yes, you do. And so the US Supreme Court took the decision, and Young versus UPS has now been decided just very recently. And really, really interesting decision if you practice in this area. It's a very unusual decision. So these are the basic facts. That's pretty hard to see from there, but you have the slides. Or do you guys have the slides? You don't, do you? We can get those to you. Okay, if anyone's interested, just email me and I'm happy to send you the slides. But anyway, Peggy Young was a part-time driver for UPS. And as part of her job, she picked up packages, she delivered packages. And it was a requirement that you be able to lift up to 70 pounds. So that sounds hard, not pregnant, and potentially up to 150 pounds with assistance. When she became pregnant, and Ms. Young was an interesting, in terms of her pregnancy, she had had a number of miscarriages. And so when she got pregnant, her doctor said, no lifting more than 20 pounds during the first 20 weeks of pregnancy, and then after that, no more than 10 pounds because of the risk of miscarriage with her. So what do? You're UPS, and your employee comes to you with this scenario. She's a driver, she has to lift packages.
She doesn't deliver the big packages.
Yeah, I don't know if and that's a really good question, because it's like, you always have to be thinking about, can we change things, but I don't know if that's plausible. I don't know if the truck's loaded and there's multiple all the stuff Christina orders from Overstock and everything else, but but that's always a good question, like, is there a way to change things to make it work? But in this case, and something really critical to know about this case is her case came up in 2007. So it was before the ADA was amended to make, the definition of disability so much broader as we understand it now. So this really isn't an ADA case. She brought an ADA claim, but the disability definition back then was so strict. So keep that in mind, because this case would be so different now, applying the ADA. But What became interesting in this case is UPS was subject to a union collective bargaining agreement that explicitly required them to provide alternative work assignments, basically light duty, if someone had an on-the-job injury. Not an off-the-job injury, but an on-the-job injury. And that's not an unusual, thing. That's a very common policy. And they also agreed to make a good faith effort to comply with requests for accommodation if someone had a permanent disability under the ADA. They would, try to put them in another job, a light duty job, have them deliver the packages. And then finally, they had agreed that they would give inside jobs, meaning inside, not driving the truck, if drivers lost their DOT certifications. And one thing that was, I thought, really fascinating is the case talks about at least one employee had been accommodated because he or she had lost their DOT certification for driving under the influence. So they were accommodating a drunk driver, but not a pregnant employee. It seems kind of like a bad fact, but anyway. But from UPS's perspective, this is what they worked out with the union. And these are gender neutral policies. And they're pregnancy neutral in the sense that if a pregnant employee falls in one of those categories, fine. But they, allow these people to take, have light duty jobs, but not a pregnant employee. So when she requested that, she have, some sort of accommodation to deal with her lifting restrictions, they said she couldn't work during her lifting restrictions. They wouldn't put her in a different job. They wouldn't accommodate her. And she brought claims under the PDA and the ADA. But like I said, the ADA was completely different then. So this is really an ADA case. And for whatever reason, she only brought a disparate treatment claim. She did not bring a disparate impact or any other kind of claim. But she said you failed to accommodate her pregnancy when you were willing to accommodate other employees. And that's treating a pregnant employee different than other employees with similar restrictions. Maybe someone hurt on the job also can't lift more than 20 pounds and they're being treated differently. And so this really came down to how do we view that second clause of the PDA? So the second clause says, women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes as other persons not so affected but similar in their ability or inability to work. And remember, this is on top of the first clause that says pregnancy is included in sex discrimination under Title VII. So this is on top of this. And, we know from, constructing legislation that no language is considered superfluous, right? So why is the second clause here? What does it mean? It kind of adds, it's sort of this quasi-accommodation. It's really odd in sort of a Title VII scenario, but what does that mean? Treating them the same as someone similar in their ability to, or inability to work. Well, obviously Ms. Young said that means if you're treating a drunk driver and, someone who's hurt on the job, by giving them an accommodation, then I should be given an accommodation because you're treating me differently. And that was her interpretation. And she presented evidence that some coworkers were willing to help her lift, that other drivers had been accommodated that had similar lifting restrictions for different reasons. And then she also had, this was disputed, that this is, for purposes of summary judgment, viewed it, light of in favor of her, that the division manager, when she talked to him about it, said, you're too much of a liability, you need to come back when you're no longer pregnant. So, that was her case. And UPS, of course, read that second clause very differently. UPS was saying, okay, we can't treat them differently. Fine. Pregnant people are not treated differently. If you fall in one of those categories, you will absolutely be given the same accommodations, whether you're pregnant or not. And both of those seem to kind of work with the language, and no idea exactly what Congress meant by all of that. Now, the trial court granted summary judgment for UPS, Fourth Circuit affirmed, and when it came up to the Supreme Court vacated the Fourth Circuit decision and held basically that McDonnell-Douglas analysis applies to establishing a prima facie disparate treatment case under the PDA. And so those of you who know employment law, there's this McDonnell-Douglas shifting that goes on. The plaintiff has to show a prima facie case and, basically that they are in the category that's protected by Title VII. They were denied some benefit, shifts back to the employer to show that there's some non-discriminatory reason, and then back to the plaintiff to show that, that they're just making that up, that that's pretext for discrimination. And so they apply it here, and it's really interesting because I think they were really trying to deal with the fact that she had not brought a sort of classic Title VII claim. She brought a disparate treatment claim. And they applied it here, they applied it in a very interesting way. They didn't accept either of those definitions, not the plaintiff's definition that if you treat, if you accommodate one person, because if you take a plaintiff's position to the extreme, she's basically saying, if I can show you one person that you accommodated and you don't accommodate me, you're treating us differently. And the court was like, well, that doesn't make sense. There might be, and one example they used is, what if an employer has a policy that people who work in super hazardous areas get hurt on the job? We're gonna have a special rule for them that they'll be accommodated. Does that mean we have to do that for every pregnant employee? So they said, that goes a little too far. But UPS's position that, as long as, pregnant employees hurt on the job, they're entitled to the same thing. That doesn't make sense either, is really not taking into account the fact that Congress was saying, pregnant people need to be treated the same. So it kind of took a middle road. It's a little hard to figure out, but we'll see if we can kind of unwrap it. So the court said that if an employer, denies a pregnancy-related accommodation, the employee can show a prima facie case under the PDA by showing she's in the protected class, she's pregnant, right? She asked for an accommodation, they didn't accommodate her, and the employer did accommodate other employees similar in their ability or inability to work. So she can do that here, right? She can show that other people were given that accommodation, but she was not. So that's her prima facie case. Now, after she makes out a prima facie case, the employer may seek to justify its refusal to accommodate pregnancy by showing a legitimate non-discriminatory reason, which is sort of your normal McDonnell-Douglas. But what was interesting here is usually an employer can come up with any non-discriminatory reason. As long as it's truly not discriminatory, it can be, we didn't like you, this was hard, all kinds of things. Here, the court made it much more difficult for the employer. They said that consistent with the PDA, you can't just say that it's more expensive to add pregnant employees to the list of people who can be accommodated. You can't say that it's less convenient to add them. You can't just say that adding them as a group of people who can be eligible for accommodation is just kind of hard and expensive. You have to come up with something more than that. So this was pretty pro-employee, at least from my point of view, and making it pretty hard for the employer to come up with a reason. And then even if the employer can come up with the reason, the burden shifts back to the plaintiff, and the plaintiff can show that there's an issue of fact if she can show that the policies impose a significant burden on pregnant workers and the reason offered by the employer really isn't sufficient enough to justify that burden on pregnant workers. So as far as I can tell by reading this, and anyone who's familiar with the case wants to chime in, please do, and the employer has to really say, we accommodate this group, And there's a really good reason for doing that and not including pregnant people. And that's going to be pretty hard to show. Like I said, there might be some rare circumstances where maybe there's a seniority program, maybe there's, like I said, someone working in a super hazardous area is hurt on the job, but I can't see very many scenarios where that's going to fly. If you categorically exclude pregnant people as someone who are, this all comes back to the fact that the employer had a policy where they allowed light duty for some people. Now, if they don't have a policy that provides light duty for anyone, then that's not discriminatory. Now, then you'll be talking about ADA, of course, but you won't have a PDA claim. So this only comes into play where employers have at least either have a policy where they provide some sort of accommodation for other employees. And here it was light duty, but it could be anything. It could be time off, it could be other things. Or they just have a practice of doing it. They have accommodated people. Someone had a heart attack and they let them have light duty for a while. And why doesn't the pregnant woman get that? So it's a really kind of unusual case. It's not the normal McDonnell Douglas analysis, and it's pretty pro-employee in terms of requiring employers to not discriminate against pregnant employees and allow their policies that allow accommodation to apply to pregnant workers. Any questions or comments so far? Yeah.
I do. What I've been kind of thinking, what the approach would be a temporary medical condition.
Mm-hmm.
But then you indicate that the Supreme Court says the burden, the issue is there a significant burden on the pregnant worker?
Right.
Isn't that usually, is there a undue burden on the employer to accommodate?
So the employer, this analysis is all just kind of turned on its head. And you're talking ADA undue hardship comes in directly, but here in terms of discrimination, if an employer has already decided that they're willing to provide accommodations for some employees, they've already said, okay, it's not an undue hardship to do it for some people. So what's the reason we're not doing it for pregnant employees? And I think I have this in my slide, but this is, the court said that if the facts did show up, the fact that UOPS accommodates most non-pregnant employees with lifting restrictions by categorically failing to accommodate pregnant employees, that would probably not be a sufficiently strong reason. There's what's the justification for that? And they also talked about if it turns out that whatever the employer's policy is, that they're accommodating a lot of non-pregnant employees and they're not accommodating pregnant employees, that's probably going to be enough for it to go to the jury. Yeah.
One area that Idaho employers probably should look at is, in like many states, Idaho employers often implement a return to work program to minimize their time loss benefit exposure for an on-the-job work injury. So even though that doesn't sound like pregnancy related, that's where the exposure is triggered often now given.
Absolutely.
And so in terms of if you're looking at which policies and practices to identify, that's often your return to work program under your workers' comp policy, which sometimes is in your risk management program, not your HR program. So
right. So just like UPS had a policy that if you were injured on the job, you could be given light duty. That's a very typical policy for return to work under workers' comp. They want to get people back to work. So, you'll have a policy that they can come back to work, they can have light duty until they're recovered. Now you have to question, is that policy, being allowed for pregnant employees too? I mean, how is their situation that different? They have pregnancy by its nature is a temporary condition, right? Not more than 9 months, and probably whatever the condition is doesn't manifest until later in the pregnancy. So that you're absolutely right. That's one of the big risk areas. Yes, sir.
Yeah, I had a couple of questions. They really relate more to the ADA because I'm seeing the.
We're going to go a lot into that.
Oh, then you want me to hold that on?
If you could ask.
Okay. First of all, I would always advise employees under the old ADA, the Pre-Amendment Act, that normal pregnancy, whatever that is,
Mhm.
is not generally considered a disability.
Right.
And that was very true, easily kind of the answer under the pre-2008 amendment. I'm wondering what your take is on that issue. If I said, okay, it's a quote unquote normal pregnancy, would that possibly be a disability in your eyes under the amended act?
So the EOC has official opinion that a normal pregnancy is not a disability. You have to show something more. And we'll kind of go through a list of things, but there's a lot of things that could come up.
And then, then the other issue is under the ADA, I think the way the law breaks out is that generally, if you do have a disability and you have a duty to accommodate, the employer does have to change its policies to make it, if it's not an undue burden, then it's a reasonable accommodation. But written on top of that is the one ADA decision on accommodation, which is Barnett, which basically says a union contract will generally trump a disability. And I guess my broader question is, did the employer try to argue in this case that, hey, we negotiated a deal, Barnett says that we don't have to change a union contract as opposed to one of our own policies? And I'm just wondering.
But that case was an ADA case.
Exactly.
This is a PDA case.
Right. I was wondering how much into the ADA, because this is starting to move toward an accommodation issue. The second provision is really being read as
That's what is so unusual is the PDA, purports to be just an amendment of Title VII discrimination, but the second clause is really moving into accommodation territory, and then we have ADA on top of that. So it's tricky, but so I mean, there's a lot to still be worked out. But in this case, the United States Supreme Court, despite the fact there was a collective bargaining agreement, said, it was, potentially discrimination, remanded for, further rulings, but potentially discrimination to not include pregnant employees when you had policies like that. So I think unions are pushing more now to have policies for pregnant women as unions become less of a men's world. That's, a more common, for example, I think the AFL-CIO, that's something that they push expressly, is to have accommodations for pregnant employees. Yeah.
So with this analysis, since this really focuses on accommodations, this would include breastfeeding after somebody comes back, and whether an employer would accommodate somebody or would not accommodate, give somebody some time to breastfeed compared to if the employer had a policy, maybe they let somebody check or if they were diabetic or something like that. You'd have to find some sort of
it all comes down to all comes in. The PDA is all about discrimination. There's not an affirmative accommodation duty, but if there's some other employees being given a benefit, you have to question whether that should apply somehow to the pregnant employee. Now there's the lactation rules, and employees have to be allowed time and space to pump milk. So, that's already the law. So, whether, so you're talking about something in addition to that?
No, actually, that answers the question. Right?
Yeah, okay. But you're absolutely right that say a diabetic employee was given time off, time off work, to go check, then you have to start saying, okay, do pregnant employees need to go take a rest or a break, and why is there any difference in the treatment of those two employees? Okay, so one thing that was interesting is the court completely disregarded the EOC guidance with respect to just this question of how to interpret the second clause of the PDA. And they really called the EOC out on exactly what they did, which is they rushed out this guidance to try to influence their decision. And they said, this wasn't thorough, wasn't consistent with their prior positions, and we're just basically not going to give it credence in this case where we normally give EOC guidance more credence. So, but what does that mean for the rest of the guidance? the rest of the guidance, I mean, I guess we'll find out as it comes up, but the rest of the guidance seems pretty strong to me. It's mostly about ADA accommodation, and it seems to be on point with respect to what the law is and some really good examples. So they didn't throw it out, the Supreme Court didn't throw it out altogether. It was just on that one small point. And it was that one small point that caused the EOC to get that out so quickly. So I think the guidance is still pretty helpful for other purposes. So we have to ignore the EOC guidance in terms of how they view Section 2 or Clause 2 of the PDA, that, you know, if there's anyone out there who has been given an accommodation, you have to accommodate a pregnant employee. But otherwise, you know, the guidance has a lot to add. And they also, you know, they rejected both sides' positions, both that it should be construed extremely broadly and very narrowly. They took a more middle view, which seems to make a lot of sense to me. And this was something they said in particular that I thought was interesting. They said that if they took Young's approach, that if you can find anyone who's been accommodated, then you have to accommodate a pregnant employee, but not anyone else. So you're basically giving pregnant employees most favored nation status, whatever that is, that you're really elevating them to another level. And, you know, there needs to be a more complex analysis than that. An employer might have a policy where they accommodate a, you know, small segment employees that makes sense, that doesn't require them to accommodate pregnant employees. But again, I don't think there are very many scenarios where that's going to fly, but at least the concept is out there that that's a possibility. And, you know, some of the examples they threw out in their language, just to kind of, you know, look for what they might be thinking of, they say those with particularly hazardous jobs or those whose workplace presence is particularly needed. So maybe they would accommodate someone who was absolutely critical for the job, but not accommodate other people, or those who've worked at the company for many years, or those who are over the age of 55. So those are at least some concepts that they threw out there that might be, you know, areas where the employer is accommodating a small group of people and maybe don't have to accommodate pregnant employees. But as an employer, I'd be pretty concerned if I wasn't including pregnant employees. Okay. So let's move on to the EOC guidance, because I really want to unpack what's in there that I think is still really useful. So the guidance has three areas: ADA accommodation of pregnancy-related disabilities and childbirth-related disabilities, then discrimination in how employers write their policies. And again, that part you can disregard because Young said it went too far. And then discrimination, how employers treat pregnant employees and parents. And that's basically stereotyping. You know, a woman's not going to work as hard after she has children. A father's not going to work as hard after he has children, those sort of things. But the ADA part in particular, I think, is still very useful. So, you know, the report tries to kind of deal with this strange interplay between the PDA and the ADA, and just keep in mind that Young can't provide us any answers about what the ADA is going to do now. The court noted in its decision that, you know, the Young facts came out in 2007. She was denied her accommodation in 2007 before the amendments to the ADA. So there was just no helpful analysis whatsoever about the ADA. So if you go back and think about the Young facts now under the amendments, pregnant employee comes in, she says, I can't lift over 20 pounds for 20 weeks, and then for the rest of my pregnancy, I can't lift over 10. I mean, how do you view that? What's the employer's obligation?
Reasonable accommodation.
What's that?
Was it reasonable accommodation?
Right, exactly. You have to go through the reasonable accommodation analysis of the ADA. So it's not just the PDA. So now we're not just looking at, is there a policy where other people are accommodated? That's just one part of the analysis. Beyond that, you have to just straightforward say, all right, is this a disability? Yeah, a lifting restriction is going to be a disability under the amendments. Do we have to accommodate this person? You have to engage in the interactive process, figure out, okay, what can we do? This is short term. Is there something else she can do for a while? Or, does she drive with someone else who can help her lift the heavier packages? You have to go through all of that analysis, to figure out what you have to do with this employee. So that's why you have to be a little careful with young, and, that's just one piece of the analysis. So, the EOC guidance expressly notes that, because of the 2008 amendments, many impairments related to pregnancy that now would qualify as a disability that maybe in the past would not. And that if you have one of those situations, the employer has to consider whether, they have to accommodate the employee. And here's just a list that is in the report, and it could be other things as well. But so, to your question, sir, even though normal pregnancy, I personally think during pregnancy that you should sit down and have your feet rubbed, but I guess I'm not winning the day. But the normal pregnancy is not a disability, but all of these things are requiring bed rest, high-risk pregnancy, C-section birth, anemia, sciatica, carpal tunnel, gestational diabetes, nausea that causes severe dehydration. So, not the normal nausea, but although if you have an employee at work who says she needs to throw up because she's pregnant, I think you should let her do it. Abnormal heart rhythm, swelling, depression, pelvic inflammation, postpartum complications with pregnancy. There aren't that many pregnancies that aren't going to have some complication at some point. Yeah.
I'm just curious, if all of this changed in 2008, why did BPS spend the money to take it all the way to the Supreme Court?
On the PDA issue?
Yeah.
Well, the big struggle was because it's all about these policies. It's kind of her point in a way, if we're going to have a light duty policy, do we have to apply that? Because the ADA, you might say, okay, we can't accommodate this person because, we don't have light duty positions, or, that's it. But if you provide them under another policy, they're just two completely different analysis. So, someone could potentially be very successful under the PDA because there's a policy out there that wouldn't be required under the ADA, but it exists and now it has to be applied equally. Does that make sense? I guess that's when I spent the money. But, when the case started, it was 2007. The amendments were passed in 2008, then, the regs, and then we've all tried to figure out what it means, right? So, as you can see, just from this list, and then other things could be included, there's a lot of things that could come up that would constitute a disability that would have to be at least considered to be accommodated. So we're going to go through a few examples from the report that I think are really helpful. How are we doing on time? Okay. So this is one from the report. So in Amy's 5th month of pregnancy, she develops high blood pressure, severe headaches, abdominal pain, nausea, and dizziness. Her doctor diagnoses her as having preeclampsia. Does she have a disability?
Yes.
Right. She has a medical condition, significantly impacts, major life activity, which is living, that sounds like. I have a severe headache, I can't even think. But so she has a disability. So then what?
Can you accommodate it such that she can perform the essential functions of the job?
Right. Employer has to sit down with Amy and say, interactive process. What can we do? What do you need? How long is this going to last? What can we do to accommodate you? Maybe for a while she just needs to, maybe, does it say what she does? No. But, maybe she's a cashier. Maybe she needs to sit on a stool for a while. Maybe she needs to be able to drink from a water bottle. For some reason, water bottle comes up a lot in these cases. And I think it's so hard for us to understand as white collar workers, but for blue collar workers, there's this whole environment where you don't have access to a water bottle, and that can be really important. Everyone should accommodate pregnant women having to pee all the time. I think that goes without saying. Okay, so she has a disability. You have to engage with her. You have to figure out what you can do. So this is what the EOC says. It says this evidence indicates she has a disability since she has a physiological disorder that substantially limited her ability to perform a major life activity such as standing, sitting, walking, cardiovascular, circulatory system. I mean, there's so much. There's so many categories now. So we've already talked about what does this mean. You have to do the interactive process. So if an employee has a pregnancy-related disability under the ADA, they're entitled to an accommodation if it can be done without undue hardship, just the normal ADA analysis. And a reasonable accommodation, as we know, is some sort of change in the workplace or the way the things are done that allow the employee to perform the essential functions of their job, unless it causes the employer an undue hardship. So what if, let's go back to Ms. Young, the UPS driver. Essential function of the job to lift 70 pounds. Written in the job description, been there forever. Do you have to accommodate that? Do you have to take out that essential function? Yeah.
I don't think you necessarily have to eliminate the essential function, and she can't do it at all because of her condition, but you have to look at potentially other jobs as well that would be available to her through the employer that doesn't have that as an essential function, but whether or not that 70 pounds is the essential function is kind of the question. But it's my understanding that if it's an essential function of your job and you can't do it because of your disability, that doesn't mean that they have to then just give up that function.
Well, this is where employers get stopped because the law is you don't have to eliminate an essential function of the job. You only have to accommodate someone so that they can do the essential function of the job. However, great big however with capital H, what do courts do? They say, is that really an essential function? Let's look at that. Remember, Young said that she rarely lifted, and I don't know what she was referring to in terms of pounds, but that was rare. Is it essential in the sense, is there someone else driving the vehicle with her that they could do it for a period of time? When you're talking about a temporary, maybe if someone can never lift 70 pounds again, that's a different situation. But if they can't lift 70 pounds for a period of time, is it essential that they be able to do it every single day? Or is there a period of time that, something can be done about it? Yes, can you move them to another job? You have to consider reassignment, temporary reassignment, those sort of things under the ADA. So it's complicated. You say they have to perform the essential functions, but it's a little more complicated than that. Yes, sir.
If you were to take that same issue and go back to the PDA claim,
right?
It strikes me that the issue there would be to bring under a Title VII PDA kind of claim, a disparate impact claim, where you're setting up this ostensibly neutral job requirement,
right?
But we find out that it's really not needed. It's the same problem we had when women were kept out of firefighting and fire departments and police departments. There would be some unreasonable lifting requirement.
Right, a physical test.
Never really required.
Right.
And those were the disparate impact cases.
Right.
So I guess my question is, would Ms. Young have had a better shot under the PDA by framing her claim as a disparate impact claim?
Yeah, she should have added that at least as another avenue. She had pretty good luck as it was, but absolutely, there's different ways to go with this. But an employer, again, you just have to be so careful because it's so easy to say, oh yes, we don't have to change essential functions, but it's not quite that easy. And you have to look at all the policies that you have. And then, hardship, that's always, is it a hardship for UPS to let her not lift over 20 pounds for a period of time, or to have light duty or do something different for a short period of time? For UPS, that's going to be a harder case. They're a very big company, right? Now, if you're a smaller company, it could be a very different result. That could be an undue hardship if your key employee, they're the person who lifts everything and they can't do it. That could be very different. Yeah, Maria.
When you're looking at these accommodations, my question is going to be set up sort of like a mathematical equation.
Oh no, I can't do math. I don't do math.
If this much work needs to be done, you have 2 employees, one is asking for an accommodation, so presumably the other employee or other employees are there to pick up the slack. So how do you, or what kind of guidance do you give employers when they're dealing with perhaps the other set of disgruntled employees who are picking up the slack, or even just seeing that somebody's getting by doing less? I get the point that we need to accommodate this person, but what about everybody else who doesn't need an accommodation but is picking up the extra?
Basically, you can require them to do so. Assuming that we're not, if it is way overboard, then we're in the area of undue hardship, right? But if you're talking about someone picking up a little slack for a while, then basically you have to allow that, and you're going to have to communicate to those employees that you can't give them the details. With pregnancy, it's a little different because it's usually obvious, right? When I'm pregnant, it's very obvious, but in other situations where someone has a psychological disability, for example, sometimes you have to communicate to employees that they're going to be picking up a little slack, but you can't give them the details of what the issue is. So it can be a little bit complicated, but yeah, it might mean that employee who never has been pregnant, it has to do more. So that's just how it is. Okay, again, sorry, this is hard to read in this room, but these are some of the accommodations the EEOC guidance says you should at least consider with respect to a pregnant employee who needs an accommodation. So light duty, alternative assignments, disability leave, and this is really important, even if FMLA does not apply. So again, another area where employers can get tripped up is they think, we don't have 50 employees. FMLA does not apply. I do not have to give you leave. Not necessarily. Some amount of leave might be, what if an employee needs, to be home for a week because she's having severe nausea? You have to do the analysis. Is that an undue hardship? Is that something you can accommodate? What if she needs a month off? What if bed rest? You have to consider it, leave, at least as a possibility. Extended unpaid leave, redistributing marginal or non-essential job functions, making everyone else do everything else. Altering how a function is performed, modified policies regarding work breaks, more frequent breaks, modifying schedules. So if someone has severe morning sickness, can they come in at 9:30 instead of 7? There might be employers like, no, we started at 7. And when you really look at that, it's not essential that they be there at 7, and 9:30 is fine for a period of time, right? Purchasing or modifying equipment, a stool, allowing a water bottle. If you're not allowing a water bottle, you better have a good reason. Okay, so here's another example. So the manager of a market is given a 20-pound lifting restriction for the last part of pregnancy because she has sciatica. Does everyone know what that is? I had a friend who had this during her pregnancy. The sciatica muscles bones are down here, and it was extremely painful. She had to go to physical therapy all the time. She had to wear weird contraptions. And anyway, so usually when the delivery truck comes, one of the stalkers unloads. About 2 or 3 times a month, the manager has to do this because the stalker is late or absent. So what do? So this is something the manager does 2 or 3 times a month, because you can never predict if the stalker is going to be absent. Yeah.
Well, couldn't
I mean, I'm sure that those aren't the only two employees at this market. Could the manager cover for the cashier and the cashier can go back? I mean, there's all sorts of possibilities.
Yeah, I like your
It's not the
thinking.
only one.
Yeah, I like your thinking. That's what's important, is having that flexible thinking, not just be like, oh, nope, she does it 3 times a month. And so you have to think broader than that. So the court says, since one of the cashiers is available to unload, the employer can remove the marginal function during the pregnancy restriction. And it's a marginal function because she's doing it 2 or 3 times a month. What if she was doing it every single day? Then it becomes a little harder analysis, right? Here's another example. Warehouse manager develops pregnancy-related carpal tunnel syndrome and is advised by her physician to avoid working on a computer keyboard. She's responsible for maintaining the inventory records at the site and completing a weekly summary report. This is an essential duty of her job. Yeah.
What are those people do by dictation?
You guys are just so smart. So the regional manager worked with her to find an accommodation. This is how the EOC always writes everything. It always works out lovely. She approves a plan whereby at the end of the week, the employee's assistants input the data required for the summary report into the computer based on dictated notes, with the employee manager ensuring the entries are accurate. So it's that flexible thinking again. Is there something other than the keyboard? Yes,
I
ma'am.
want to change this a little bit. Let's assume there are 3 people in that office.
Uh-huh.
And nobody's available to help input. And that's an essential function. What's the answer?
Nobody's available to help? So it's just, well, that's probably undue hardship, but I mean, you have to think. You have to really put on your thinking cap and make sure, because it all goes down to, if I go to a jury, are they going to come up with something? Are they going to think that was, being draconian, or that really truly was an undue hardship? Yeah.
Dictation, and I don't mean by another person, I mean by computer program.
So computer program dictation, she's saying. There are programs where you dictate and it just types.
I like that accommodation better, but do you think they can force the employer to hire someone at a relatively low salary rate to do it?
I've never seen hiring another employee as something that would be required to do. But have you seen that?
I mean, if you have a person who can't see, you might want to hire someone to escort them up to upstairs. I mean, I don't think hiring is out of the question.
Yeah. Yeah, well, you never know what's out of the question.
I think that's a better accommodation.
Yeah.
It's a lot simpler.
Yeah. Okay. It depends on the size of the employer, obviously. It's a big difference. Here's another one. An account representative at a bank is diagnosed with cervical abnormality, is ordered to remain on bed rest until she delivers. The employee has not worked long enough to qualify for FMLA. She has some sick leave, but not enough.
Wouldn't it fall under the guidelines of accommodation or the recommendations, the strong recommendations to allow her to come back to work?
Well, you have to at least consider whether giving her additional leave is something you can do as an accommodation without undue hardship, right? And back to the PDA, be looking at your other policies and your history. Have you allowed other people, was there someone who had diabetes and you let them have some extra time off? You have to, consider all of those points. So what does the EOC say? They say the company determines that it would not be an undue hardship to grant her request for sick leave beyond the terms of unpaid sick leave. Of course, that's what the EOC says. Yeah.
Well, I'm not sure that account representative of the bank, but a lot of cases they're looking now, can people from work while they're on med rest, or can we provide some accommodation where they can do work at home?
Telecommuting. So yeah, the big thing, really big area in the ADA now is telecommuting, a reasonable accommodation. And it's so dependent on the job, right? If I'm a factory worker on a line, I can't telecommute. Can a lawyer telecommute? I telecommute all the time. You can't telecommute to court though. So, it's so fact dependent, but it is something you have to consider, absolutely. Did you have a question, Amy?
Sorry, I know we're out of time.
If you're a large employer, is the general rule that you have to do
More?
almost any accommodation?
No.
To me, it seems like, if you take the UPS example, I never see two drivers in the same UPS.
Yeah, and I don't know what the situation was.
There's stock prices in the toilet, and Amazon is just gonna deliver stuff by drone.
Yeah.
They really have to.
You know, unfortunately, that decision didn't give enough factual detail to understand, because she said, for example, that her coworkers were willing to help her with the heavier packages. I don't know if that means putting them on the truck. I don't know what that means specifically in the context of that job. But your question, does a larger employer have to do almost anything? Well, they don't have to do almost anything. There's the undue hardship analysis still applies, but a larger employer is going to have a greater duty. Absolutely, they have more. This analysis, is there a legitimate non-discrimination reason? Is there an undue burden on pregnant employees? And just remember, you cannot categorically define out pregnancy. We can go through some more examples, but I don't know if do we need to shut this down? Yes? Am I getting the yes? Yes?
One comment I wanted to make that I've noticed in clients that have came in is employers that are regarding the pregnant person as having a disability, and therefore then taking an adverse employment action based on assuming that the pregnancy is a disability when there is no complication.
And like, what would be the example?
For example, demoting somebody because of figuring that they wouldn't be able to handle the stress of the position while they're pregnant.
Yeah.
And
Not only would that be regarded as under the ADA, that would be direct discrimination under Title VII and the PDA, because you were saying.
This was in the context of the ADA that I was talking about. Notice
Yeah.
regarded as employers are getting in trouble
Yeah.
assuming that the pregnancy is
Right.
disability.
But, and besides that, they're stereotyping. They're saying, we don't think you're pregnant, so you can't handle a stressful job. And, that's direct discrimination. So that would fall in a lot of categories. So do you guys want to go through a few more examples, or do we need to? Anyone can leave anytime they want. Okay.
Let's say thank you, and then anyone that wants to stick around.
Okay,
But just like to give you a nice round of applause.
Okay.
Thank you so
Yes,
much.
Oh, thank you. Wow.
And you're very clearly very effective in the courtroom and the classroom.
Okay, thank you. Yes, thanks, everyone. It was super fun to be here.
How are you doing?
Oh, good. I know we spent more time.
Oh, I know.
Let's talk about it.
And it's just so wonderful to have so much fun.
Oh, good. Yeah, it's an interesting area.
Oh, it's absolutely fascinating, and it seems especially great for counseling. Thank you. Thanks, Dean, for setting all of this up. It made my life